So, is my garage part of my castle? Is the first question today. And um, first, let's talk about what a castle is. Of course, the term castle is primarily drawn from the concept of the castle doctrine we've all heard about. Unfortunately, it's very much uh, mistakenly understood, very over broadly understood. Many people understand it to mean that you have some kind of generalized license to just kill other people uh, in defense of your castle. And that's not what the castle doctrine means at all. Uh, Now, it's often misused even by lawyers and judges and police. So it's understandable that certainly lay people would apply that misconception to an overbroad definition of castle doctrine as well. It's just that there's two factors. Hey, Steve Gosney in the chat, attorney, Florida. SteveGosney.com for his many, many excellent books. There's two factors at play here. One is that people have just been generally misinformed about the castle doctrine. Well, I guess there's three factors. Because most of the information available about use of force law generally is bad information, and that is reflected in what people are taught. Second, people they'd like to believe in the overbroad definition of the castle doctrine, and so they become emotionally committed to simply having an emotional need to believe that their understanding of the castle doctrine, this overbroad understanding, is what it must really mean. They don't like to think that there are constraints on their ability to defend their home. Nobody would like that. There are, in fact, constraints on your ability to defend even your home. And another factor is that using an overbroad definition of castle doctrine isn't particularly troublesome if it's the correct definition in your particular jurisdiction. So I shouldn't say correct, but if everyone's using it the same way in a particular jurisdiction. So first let me define what the castle doctrine actually means, properly understood. Very narrow definition. What it means is if you would have had a legal duty to retreat before defending yourself in a confrontation, if you were out in public, like on a public street, you are relieved of that legal duty to retreat if you're defending yourself in your home. So typically there's up to 5 elements of a claim of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Avoidance has to do with this legal duty to retreat. There are really only 11 states that impose a generalized legal duty to retreat before you can use deadly force in self-defense in an otherwise lawful case of self-defense. 39 states do not impose a generalized legal duty to retreat before you can use deadly force in self-defense if in an otherwise lawful case of self-defense. Speaking generally here, of course. But in every state, if you would have had a legal duty to retreat, you're relieved of that legal duty if you're defending yourself from a genuine intruder in your castle. That's all castle doctrine means. You're relieved of the otherwise existing legal duty to retreat. What many people misunderstand is that they imagine that the castle doctrine gives you broadened authority to use force in defense of your castle. It doesn't do that, properly understood. Now, there are other laws that do that. There are what I refer to as highly defensible property laws that do give you broadened authority to use deadly force in defense in the context of your home. But those vary enormously from state to state. The one definition of castle doctrine that's consistent from state to state is this being relieved of an otherwise existing legal duty to retreat. What people often do is they take those other laws, those highly defensible property laws that exist in their state in some form, a form that's different from the next state over or state on the other side of the country. But in their state, they take those highly defensible property provisions and they also label those as castle doctrine. Now, if you do that, and the only people you're conversing with about this issue are also within the same state, so you're all talking about the same castle doctrine, and you're all talking about the same bucket of highly defensible property laws, then there's no confusion. You are over broadly applying the term castle doctrine, but it's harmless because you're all over broadly defining it in exactly the same way. The difficulty is when you begin doing that across state lines, because then you're taking castle doctrine plus the bucket of highly defensible property laws, combining them in one state and getting a particular combination, and doing the same thing in the next state over, except in the next state over, the bucket of highly defensible property laws is different. And so the combination you get is different, and the legal outcome would be different. But because both of the people in those different states are using the term castle doctrine to refer to the combination, the different combinations, it sounds like they're talking about the same things. But they're not. Because that added bucket of highly defensible property laws is different in one state from the other state. So they're actually talking about two different things. And of course, at law of self-defense, we're always, well, not always, but especially in our live streams, by the nature of being live streams, they're not state specific. So we're talking about the commonalities across states. And the only version of castle doctrine that's common across the 50 states is this narrow definition that the castle doctrine relieves you of an otherwise existing legal duty to retreat, period. That other stuff, the additional provisions for the defense of highly defensible property, vary enormously from state to state. So just starting with that clarification. Using the term castle more generally to refer to your highly defensible property, let's use the word dwelling instead. Your dwelling is always highly defensible property. Some states then expand the definition of highly defensible property to also include an occupied vehicle or a business. Some try to include a church, for example, although I'm not sure that's been successful anywhere yet. And the advantage of defending yourself within the context of highly defensible property, however your state defines the scope of highly defensible property, is these additional broadened provisions you get for the use of deadly defensive force. So a common one, for example, is the creation of a legal presumption that you have a reasonable fear of unlawful, imminent death or serious bodily injury when you're defending against a forcible, unlawful intruder into your highly defensible property. What's the value of that legal presumption? Well, remember, there's up to 5 elements of a claim of self-defense, right? Innocence, imminence, proportionality, avoidance, and reasonableness. These are cumulative. So all the elements that are required are obviously required to have a valid claim of self-defense. That means that each of those elements effectively becomes a target of attack for the prosecutor. He only has to disprove any one of them beyond a reasonable doubt. And if he does that, your entire claim of self-defense collapses. The nice thing about this legal presumption of reasonableness in the context of highly defensible property is if you look carefully at what it's saying, it's creating a legal presumption that you had a reasonable fear of imminent, unlawful, deadly force harm at the hands of that forcible and unlawful intruder. Reasonableness is one of the 5 elements. Imminence is another of the elements. Unlawful means you're the innocent party. That's innocence is a 3rd element. And deadly force harm addresses the issue of proportionality, the degree of harm you're facing. It's giving you, literally, that legal presumption is giving you 4 of the 5 elements you need for lawful self-defense. And then the castle doctrine that relieves you of an otherwise existing legal duty to retreat takes care of avoidance. So this legal presumption is effectively giving you everything you need to justify your use of deadly defensive force in the context of highly defensible property, where you would not have the benefit of that legal presumption if you were defending yourself out on the public street. It's great stuff. Now, you do have to qualify for that legal presumption. As I said, you need to be defending yourself typically against an intruder who's both unlawfully present and who entered forcibly. They broke something to get in. There's also commonly a lot of exclusions you need to not trigger. Often you need to not be using the highly defensible property for unlawful purposes. So if it's you're selling drugs out of it, you may not qualify. Often the quote unquote intruder must not have been a police officer acting in the course of their duties and so forth. It doesn't mean you can't defend yourself in those scenarios, but it means you wouldn't get the benefit of that legal presumption. But if we're talking about highly defensible property in the context of your dwelling, where you live, and the dwelling's always included within the definition of highly defensible property, a question that comes up frequently is, well, what about my garage? Is my garage highly defensible property? This has come up in Colorado in particular. We had a case down in Colorado Springs where this came up in an interesting way. So Colorado's highly defensible property statute doesn't create a legal presumption. It does something different. It's infamously called the Make My Day law. And basically it says, if you're defending yourself against an intruder in your home and they threaten you with any degree of force, any, even mere non-deadly force, you're privileged to use deadly force in self-defense. It's a remarkable statute, and I'm very much in favor of it. I fully expect our new communist legislature to eradicate it in the near future. One of the many reasons I'm fleeing. I'm a political refugee in progress from the Rocky Mountain State. But that's Colorado's version. And so when people defend themselves in the context of their home in Colorado, they're often raising this Make My Day statute as part of their legal defense. And it's come up in the context of garages. And the way it's fallen out in Colorado, because the statute itself doesn't address this question, is if the garage is attached to your house, to your dwelling, it's part of your castle. And if it's unattached, it's not. So if you're defending yourself in Colorado against someone in your garage, and that garage is attached to your house, you have the benefit of the Make My Day law. But if the garage is unattached, you don't. And it kind of makes sense. The whole reasoning behind the castle doctrine, why you're relieved of an otherwise existing duty to retreat when defending your home, is that the reason retreat was imposed in the first place was on the theory that you could retreat to a safer place than you were in. So you're out in public, you're being threatened. There's a safer place you could go to that would protect you, making that move without you having to use force against that other person. But if you're in your home, there is no safer place for you to go. Well, if your garage is attached to your house, there's really no safer place for you to go either. It's part of your castle. But if your garage is detached, well, in theory, you could leave your garage and then go into your home. And that's how it generally works in most states in the case law I've seen. Now, state statutes generally don't address this question specifically. So you have to read appellate court decisions to see how this works out. But this is generally how it works out. So generally speaking, if your garage is part of your castle for both castle doctrine and highly defensible property purposes if it's attached to your home, and not so if it's not attached to your home.